皆様こんにちは。米韓のマッケンジー法律事務所の弁護士の増本です。US Litigation Now 3では、これまで米国訴訟における文書開示の手続きや文書開示手続きを見据えた文書保全の必要性についてお話をさせていただきました。本日は文書開示手続きにおいて提出すべき証拠を破棄してしまった場合、つまりスポリエーション・オブ・エビデンスについてお話をさせていただきたいと思います。本日のスピーカーは、弊社サンフランシスコオフィスパートナーのマーク・グッドマン弁護士と、ワシントン DC オフィスパートナーのジェニファー・セムコ弁護士です。Hi, Mark and Jennifer. So today we want to talk about spoliation evidence. So first of all, could you explain what spoliation evidence means?
Yes, Mika, thank you very much. And it's so good to see everybody today. So spoliation of evidence, we've touched on this in some of our other presentations we've done. So hopefully some of our fans will be familiar with these concepts. But as people who followed us know, in the United States, litigation involves very broad discovery, which means that parties are entitled to obtain documents and other information relating to litigation from their opposing party. And because of that right, it's important that parties preserve and maintain documents and information so that they are discoverable. And so where spoliation comes into play is US courts will have a very high expectation about what parties will do to maintain their documents and make sure that they keep them, especially if litigation or disputes may be coming. You're expected to protect your documents and keep them and not destroy them. Spoliation is where a document or documents are destroyed even though litigation should be reasonably anticipated or a dispute becomes more obvious. And so the idea is you can get in trouble if you destroy evidence. And this can obviously happen accidentally, where somebody accidentally deletes something or a computer system crashes, or it can be part of a company's document retention policy. They have a very short document retention policy, so they destroy documents more often than what you're used to in the United States, which will not be looked on favorably. Or of course, the most dramatic incident of spoliation is where somebody actually intentionally destroys a document because they think it's a bad document. There's a bad email and I want to delete it because I don't want anybody to see it. If that comes out, then there are serious repercussions that parties will face.
So how will spoliation evidence arise in the US litigation?
So as Mark described, in our U.S. litigation procedures, the parties are expected to exchange documents and other evidence relevant to the case. And so spoliation will become an issue when that process begins. Perhaps the other side is expecting to receive documents and notices that certain documents are missing and asks about those missing documents, or perhaps the party producing the documents confesses, for lack of a better word, to the other side and explains that a certain category of documents has been lost. So during the discovery process, if it is discovered that one party has failed to preserve documents relevant to the case, then the opposing party will typically go to the judge and complain. And will tell the judge, look, these are documents that are relevant to this dispute. The other side had a duty to preserve them and did not, and therefore we believe they should be sanctioned for it. So that's how spoliation usually comes up in the cases that Mark and I and our colleagues here in the U.S. litigate.
So what does the other party have to show to seek sanctions for spoliation evidence?
So the burden is definitely on the party seeking the sanctions. And to your question, what do they have to show? Well, as you know, in the United States, we have 50 different states, and we also have both a federal court system and a state court system. So the test and the factors can vary a little bit in the US. But as a general rule, courts want to see a few things. First, they want to see that the party accused of destroying documents had control over those documents and a duty to preserve those documents at the time that they were lost. And that will usually turn on the question of whether or not the party who lost the documents knew or reasonably should have known, anticipated that litigation was going to arise. And for that reason, it can be really, really important that a company and its employees know when that trigger point arises. When is that duty to preserve triggered? Another factor that the party seeking sanctions will have to show is that evidence was actually lost, that evidence did exist and now it is gone. And believe it or not, there can often be a fight over that very simple question. The party who is expecting to receive documents will claim that those documents must have existed. And sometimes the party on the other side argues to the court that its opponent is simply wrong. There never were documents of the type that this party believes existed. So that can be another battleground. Another factor the court will consider is whether the evidence that was lost is even relevant and admissible in the case. If the documents that were lost are inconsequential and don't bear on the dispute, then the court is less likely to find that spoliation has occurred or that a sanction is appropriate, because the opponent who is seeking the documents, isn't really prejudiced in any way. So that's something the court will think about. And then lastly, the courts will think about the state of mind of the party that lost the documents. Was this done deliberately? Was this done because the party was careless and negligent, or was it purely an accident? Mark ticked through some examples of those different scenarios, and that can be a relevant factor for the court, both in determining whether spoliation occurred at all, and if it did, what the appropriate sanction should be.
Even though the party destroyed documents by accident, will spoliation motion be grounded by the court?
The short answer is yes. It is still possible to be sanctioned when the loss of evidence was purely accidental or unintentional. Now, of course, the most severe sanctions are going to be reserved for the really egregious behavior where documents were intentionally destroyed. But it is still possible to be sanctioned for accidental or negligent deletion or loss of evidence. The court is, as an overall matter, going to think about the reasonableness of the company's behavior and will consider exactly under what circumstances was the evidence lost. And the more fault the court finds on the part of the party that lost the evidence, the greater the chance that that party will actually be sanctioned.
So what kind of sanctions may be imposed by the court?
So if there are if there is spoliation, then as Jennifer said, there's a wide variety of sanctions that can be imposed. It's up to the judge who's imposing the sanctions. It's under their discretion. And the most severe sanctions, as Jennifer also mentioned, are reserved for where there is sort of egregious intentional conduct, where there's actually intentional destruction of evidence. In those cases, a judge could dismiss the case. So if you're a plaintiff and you destroyed evidence, the court could dismiss your case, you no longer have a case. Or if you're a defendant, the court can find that all of your defenses are stricken so that the plaintiff gets judgment against you. A judge can impose a requirement that costs be awarded, what Jennifer was talking about, monetary sanctions, so that there are costs, basically a monetary penalty that's imposed against parties. A court could order a party to pay the cost of having to reconstruct all of the evidence that was destroyed and go through a forensic rebuilding of databases or hard drives to recover lost data. There could be what we call an adverse inference, which is where a court instructs a jury to assume that the evidence that was destroyed was bad for the party that destroyed it. Because those can be very harmful instructions to your case, because then the jury is basically told by the court to assume that you did something wrong and you must have been hiding something. And then you can also be held to be in contempt of court, which includes criminal penalties. So in other words, you can go to jail if your conduct was egregious enough or in such a manner that the court finds that you have no regard for the court's processes and procedures. So there's a whole wide range of things, and they can be very, very serious, which is why we wanted to share these things today.
In light of the risk of spoliation penalties, what recommendation do you have for Japanese companies?
Right. So because they are such important and severe potential penalties, it's really important for our Japanese clients to be aware that these things are happening in the United States. So training is really important. Training your employees on what to do, not destroy documents, have litigation holds, work with counsel in the US, whether it's Baker McKenzie or any other counsel, to make sure you have good policies and procedures in place. Make sure that you have data retention policies that match what the US courts would expect you to have. So they'd have to be at least a year or more, and to have litigation holds if there are potential disputes, so that you will keep your documents until the dispute is over, and really have a process in place to understand what's happening with your data and documents. So you can't just say, well, I didn't know what was happening because you didn't ask. That's not going to be a good excuse.
And the only points I would add to that, obviously, it can be a dangerous period of time. It can be very significant, that period of time between when the dispute first starts to arise and before the litigation is filed. During that window of time, a court may conclude that your company had an obligation to preserve documents. And that can be unfamiliar to companies that are not used to the US legal system. And so for that reason, it's really critically important that your employees understand and learn to recognize when a dispute begins to brew, when it might lead to litigation, because that may be the point in time when your duty to preserve documents is triggered. And the last point I would add is something that companies may not always think about, and that is to make sure there is coordination, not only among the members of your legal department, but the members of your IT department and your human resources department, to make sure that each of those departments understands this duty to preserve documents, understands the existence of auto deletion and other IT policies, as well as human resources policies like the deletion of data when an employee leaves the company. Each of these departments needs to be carefully coordinated to make sure that what the legal department knows about a duty to preserve documents is shared with the other departments to make sure that things are not accidentally deleted or lost.
Thank you, Mark and Jennifer, for providing a very helpful explanation and your insights on spoliation evidence. 本日は文書開示手続きにおけるスポリエーションエビデンスについてご説明をさせていただきました。米国訴訟では文書開示手続きを見据えて適切に文書の保全を行うことが極めて重要である点、ご理解いただけたかと思います。本日はご視聴いただきましてありがとうございました。引き続き US Litigation Now 3をどうぞよろしくお願いいたします。